Yes, I hope that you can see my screen.
Yes, sir.
Okay, thank you. So during our last lecture on legal aspects of business, we had discussed remedies of breach of contract. That in case of violation of contract, or in case of breach of contract by both the parties or one of the parties to the contract, what are the options available to the aggrieved party, that we had discussed. So this, I think, we have completed. Yeah, right. Quantum merit and suit for injunction, we have already completed. So now we will move on to the another part or second part of the first unit, that is related to contract of guarantee. So before moving to contract of guarantee, first we will try to discuss about what is the meaning of contract of indemnity. Indemnity means that if a person gives the promise to the other person that in case, if in future, because of me, if any loss occurs to you, then i will then I will compensate you for that particular loss. And that is called the meaning of indemnity. And same is the meaning for contract of indemnity also. So first we will read the technical definition of contract of indemnity, and then we will take an example also. So a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called as contract of indemnity. The person who promises to make good the loss is called as indemnifier, and the person whose loss is to be made good is called as indemnified or indemnity holder. You might have heard about indemnity bond also. How many of you have heard about indemnity bond? Am I audible to all?
Yes, sir.
Okay, thank you. Thank you. So I'm not aware of the current rules and regulation of filling your scholarship form. But 2, 3 years back, the student who was supposed to fill the scholarship form, that student was also supposed to submit a indemnity bond in the college. Indemnity bond means in writing, the student is giving the undertaking that if because of my incomplete document or fake document or for any other reason, if my scholarship is rejected and if the college faces loss because of that, I promise that I will compensate the college for that particular loss. And that is what indemnity bond is. So it is very simple, a written undertaking given by one party to the other party, stating that in future, if any loss happens to that particular party, the promiser will compensate that party for that particular loss, and that is called as contract of indemnity, right? And there are two parties in contract of indemnity. One party is called as indemnifier, and the other party is called as indemnified or indemnity holder. The person who is giving the written undertaking in other party's favor, that person who is writing, who is giving the written undertaking, that person is called as indemnifier in contract of indemnity. and the person in whose favor that written undertaking is given, or the person who is in possession of that written undertaking, is called as indemnified or indemnity holder. The earlier example which I have gave you, that earlier there was a system that every student has to submit indemnity bond in the college. So the student here will be called as indemnifier, because the student is giving a written undertaking to the college that in case, because of himself or herself, if the college in future faces any loss, he or she shall be responsible for that, and he or she shall be compensating that loss which has been occurred to the college. So that student who is giving the written undertaking will be categorized as indemnifier, and as the college which is in possession of that written undertaking given by the student, the college will be called as indemnified or indemnity holder. So in simple words, we can say this is the meaning of contract of indemnity. Now next, we will move on to contract of guarantee. Now, some of you might not have heard about indemnity bond or what is the meaning of indemnity, but I am very much sure that each and every one of us, we are aware of the term guarantee. What is contract of guarantee? Again, we all are aware of. Even a student at matriculation level, that student is also aware of what is guarantee, what is the meaning of guarantee. So contract of guarantee is a contract where a person gives guarantee to the other party that in case the other person didn't pay the loan which he or she has taken, then he shall pay that loan on behalf of the other person. So that is called as contract of guarantee. Now, if we want to take loan from the bank, the procedure is very simple. We need to submit the required document, as well as we have to sign a contract of guarantee. And that, suppose I want to take loan of 5 lakhs from the bank for construction of house or for any other thing. I need to submit all the required document, plus I have to produce at least 2 guarantors in the bank who will be signing as guarantor, or it is also called as surety. Guarantor 1, guarantor 2, or surety 1, surety 2, who will be giving guarantee on my behalf to the bank that this particular person has taken loan from you. In future, if this person is unable to repay your loan, I shall repay your loan on his behalf. So that is called as surety or guarantor or guarantee. So contract of guarantee. A contract of guarantee is a contract to perform a promise or discharge a liability of a third person in case of his default. So contract of guarantee is exercised when the person who has taken the loan or against whom debt is existing, if that person makes a default, he didn't pay to the principal or didn't pay to the bank, at that moment the contract of guarantee comes into existence. The person who gives the guarantee is called as surety or guarantor. The person in respect of whose default the guarantee is given is called as principal debtor, whereas the person to whom the guarantee is given is called as creditor. So in contract of guarantee, there are always three parties involved. The person who is giving the guarantee is called as surety. The person who is taking the loan or on whose behalf the guarantor is giving guarantee will be called as principal debtor, and the person who sanctions the loan, who gives the loan, will be called as credit. So creditor, principal debtor, and surety. These three parties are involved in all the contract of guarantee. In the last contract of indemnity, we have seen that only two parties are there. One is called as indemnifier, the other one is called as indemnified or indemnity holder. Whereas in this contract of guarantee, there cannot be two parties. If there are two parties, there cannot be a contract of guarantee. For a contract of guarantee to be a valid contract, there has to be at least three parties. So three parties is a must. So one party will be called as creditor who is giving the loan. The other party will be called as, the second party will be called as principal debtor, who will be receiving the loan, who will be taking that loan. And the third party is called as surety or guarantor, who will be giving the guarantee for principal debtor to the creditor. And that is called as contract of guarantee. So contract of guarantee, again, it is very simple, as each of us are aware of what is the contract of guarantee. So it is very easy for us to understand also. Only thing we need to understand is that three parties are involved in contract of guarantee. Who these three parties are, we should be aware of, and who are the two parties who are involved in contract of indemnity, and what is the difference between contract of, when we can say that it can be called as contract of indemnity, and when we can say that it can be considered as contract of guarantee, that we should be aware of. Now we will discuss the distinction between contract of indemnity and contract of guarantee. So far, if you have not understood anything, please stop me and you can ask your query. Otherwise, we will move ahead.
Excuse me, sir. This is Ajay Gaikwad.
Yes, Ajay.
Could you please give some example in real life example of indemnity bond apart from that college example?
Now, suppose a person is there. Now, many of the students are sending their forms through courier also, because many students are staying far away. Some of the students are not well, so they are sending their forms with the help of courier or through courier. Now there is, hello, I hope that everyone can hear me.
Yes, sir.
Okay, thank you. So on the courier, the address of the sender and the person to whom it is sent, it is clearly mentioned. Now suppose if a courier, I have ordered something from Amazon, suppose, for example, very simple. I have ordered something from Amazon and I have to go to the courier office to collect my parcel. But when I went to collect my parcel, I forgot to produce the receipt or forgot the receipt of that particular parcel at my place. So when the delivery person who was at that particular office, when he inquired that please show me the receipt that this parcel belongs to you, then only we can give it to you. In this particular case, if I am unable to produce the receipt to collect my parcel, and instead of producing that receipt, if I give it in writing, that I am the original owner of this particular product or this particular parcel. In future, if somebody else comes and he is able to prove that instead of me, he or she is the real owner of this particular product, then I shall compensate you for the loss.
लवकर होतंय काय काय उशीर केलाय हे उशीर काहीच नाही लवकर आलं उलट मी माहितीये का
Mohit sir,
हो
please mute. So when I was collecting that document or that parcel without a receipt, and when I gave that written undertaking to that courier company or courier office person, that shows that we have entered into a indemnity contract. What I have written is, I have given a written undertaking that I am the original owner of this particular parcel, but in case in future if somebody else claims that he or she is the real owner and is able to prove that also, then I shall be responsible, or I will compensate you for that particular loss, and that is called as contract of indemnity, right?
Yes, sir. Yes, sir.
Okay, thank you. Now we will discuss about the simple distinction between contract of indemnity and contract of guarantee. Very simple differences are there. A contract by which one party promises to save the other from loss is contract of indemnity. Contract of
Excuse me, sir.
indemnity में क्या हो रहा है कि एक पार्टी
Excuse me,
प्रॉमिस
sir.
कर रही है दूसरी को कि अगर कुछ भी लॉस होता है तो मैं आपको वो लॉस का कॉम्पेंसेशन दूंगा या दूंगी. दैट इज कॉन्ट्रैक्ट ऑफ इंडेमनिटी. वेयर एज
Excuse
इन
me, sir.
कॉन्ट्रैक्ट, यस,
In chat box, Abhishek Pund is raised one question.
Abhishek, hello, is he there?
Can I read the question?
Go ahead.
Is a life insurance contract an indemnity contract in India?
Is
A life insurance contract an indemnity contract in India?
okay. Is it so? What do you feel? Any student? Life insurance contract, can we call it a indemnity contract?
No, sir. Because
Why no?
life is uncertain. How could one can give a guarantee of your life?
Uh-huh.
So this life insurance contract is not come under the indemnity contract.
Hmm. So try to understand, yes, try to understand that here one person is promising the other person that in case of any loss because of me, then I shall compensate your loss. LIC में क्या होता है कि we are entering into a valid contract between with the LIC company, where we are aware of the terms and conditions and we are signing that. In indemnity is when there is a question mark, when there is some sort of confusion, when there is a, say, a chance where there can be loss in future. अगर फ्यूचर में मेरी वजह से कोई लॉस हुआ तो मैं आपको कॉम्पेंसेट करके दूंगा, ये इंडेमनिटी है. तो लाइफ इंश्योरेंस इज नॉट इंडेमनिटी. Yes, in contract of guarantee, a contract to perform the promise to discharge the liability. Now, very simple difference is that indemnity will take place, or the contract of indemnity will be exercised only if there is a loss caused to the person. प्रॉमिस किया है ना, फ्यूचर में मेरी वजह से कुछ लॉस होगा तो मैं आपको नुकसान भरपाई दूंगा, इंडेमनिटी। जबकि गारंटी में क्या है, ऑलवेज देयर इज अ डेट एग्जिस्टिंग, देयर इज अ लायबिलिटी एग्जिस्टिंग। 5 लाख का मेरा लोन कब सैंक्शन होगा, जब गारंटर या श्योरिटी उसके ऊपर साइन करेगा, तब मेरा वो लोन सैंक्शन होगा। The moment the guarantor promises the bank or the creditor that in case this person is unable to repay the loan, I shall repay his loan. So that is the difference. Here you are not sure whether there will be loss or no loss in the future, but in guarantee we are very much sure that we are taking guarantee of this amount. That is why it is very difficult to enter into a contract of guarantee with a person, because creditor will be getting interest plus his principal amount. Debtor will be getting, principal debtor will be getting the loan which he can use for his personal use. Whereas guarantor is a person who will not be getting anything in return, but yes, his liability is 100%. अगर मैंने वो पैसा पे नहीं किया 5 लाख, तो क्या होगा, इमीडिएटली किसको पे करना पड़ेगा, गारंटर को। क्यों, क्योंकि गारंटर ने लिख के दिया है, और ये गारंटर को पहले दिन से पता है, जब उसने साइन किया तभी उसे पता है कि 5 लाख रुपए की लायबिलिटी है उसके ऊपर। अगर डेटर नहीं देता है, पे नहीं कर पाता है, तो उसे पे करना पड़ेगा। So that is the simple difference between indemnity and guarantee. Then there are only two parties, promisor or indemnifier and promisee or indemnity holder in contract of indemnity. Here there are three parties in contract of guarantee. First party is called as principal debtor, creditor and surety, that we have already discussed. Next, in indemnity only one contract is created between the indemnifier and the indemnity holder. तो एक ही कॉन्ट्रैक्ट होता है, किसके बीच में, इंडेमनीफायर के बीच में और इंडेमनिटी होल्डर के बीच में। और यहां पर इन कॉन्ट्रैक्ट ऑफ गारंटी देयर आर ऑलवेज 3 कॉन्ट्रैक्ट्स, इंस्टेड ऑफ 1 देयर आर 3 कॉन्ट्रैक्ट्स. फर्स्ट कॉन्ट्रैक्ट विल बी बिटवीन द creditor and the debtor. Second contract will be between the surety or guarantor and the principal debtor. Third contract, creditor and the surety. So in all the contract of guarantee, there will be 3 separate contracts involved. Next one, the liability of the indemnifier is always primary in the contract of indemnity, whereas in contract of guarantee, the liability of the surety is secondary, principal debtor is primary. Again, it is self-explanatory. In contract of indemnity, as indemnifier is giving it in writing that in case, because of my conduct, because of my action, or because of me, if any loss happens to you, I shall compensate you for that particular loss. So his responsibility is always primary. Whereas the liability of the surety is always secondary. Why it is secondary? Because principal debtor is the person who is receiving the loan, who is taking the loan from the bank or the creditor. So it is first his responsibility that he shall repay the loan. If because of any reason he is unable to repay the loan, then the surety must repay the loan. Now, essential features of contract of guarantee. Simple features: Most of the features we have already discussed, so we will take a quick look on these principles or essential features. First feature is it must possess all the essentials of a valid contract. All the contract of guarantee shall possess all the essential features of valid contract. We had earlier discussed during our initial lectures about the 10 essential features of a valid contract. So a contract of guarantee will be called as a valid contract of guarantee only if all the essential features of a contract of a valid contract is present in it. Next one, there should be existence of three one, there must be a debt existing which should be recoverable. That also we had discussed, that at the time of signing the contract of guarantee, the surety or guarantor is aware that what is the debt he or she is supposed to pay to the creditor in case of default of principal debtor. Next one, principal debtor is always primarily responsible or liable to pay his debt. Liability of surety is secondary, one which arises only in case of default of the principal debtor. Again, we have discussed this, that जिसने पैसा लिया है क्रेडिटर से या बैंक से, उस व्यक्ति की पहली जिम्मेदारी है कि उसने ही रिटर्न करना चाहिए. अगर मैंने 5,000 रुपए का लोन बैंक से लिया है तो ये मेरी जवाबदारी है, ये मेरी जिम्मेदारी है कि मुझे ही वो लोन रिटर्न करना है, मेरी पहली. अगर किसी कारणवश मैं वो बैंक को रिटर्न नहीं कर पाता हूं तो जिसने मेरे लिए श्योरिटी पे साइन किया है, जिसने गारंटर मेरे एज गारंटर मेरे कॉन्ट्रैक्ट पे साइन किया है लोन पे, उस व्यक्ति को वो 5 लाख रुपए पे करने पड़ेंगे. बट हिज इज सेकेंडरी, माइन एज अ person who has taken the loan is primary. Next one, the liability undertaken by surety must be legally enforceable. The liability undertaken by the surety must be legally enforceable. जो भी liability है, जो भी debt है, that should be legally enforceable. लोन लेना 100% लीगल है, तो लीगली एनफोर्सेबल. ऐसी कोई भी कॉन्ट्रैक्ट अगर होता है जहां पर लीगल नहीं है, वहां पर अगर कॉन्ट्रैक्ट में कोई गारंटर साइन कर रहा है तो इट इज नॉट एनफोर्सेबल बाय लॉ. सो व्हाट इज एक्सपेक्टेड इज द लायबिलिटी अंडरटेकन बाय द श्योरिटी मस्ट बी लीगली एनफोर्सेबल. मैं 5 लाख रुपए रिटर्न नहीं कर पाया तो किसको रिटर्न करने पड़ेंगे? श्योरिटी को. Why? Because this contract is legally enforceable in law. पर अगर हमारे बीच में ऐसा कोई कॉन्ट्रैक्ट होता है जिसमें मनी इज इन्वॉल्व बट दैट इज अगेंस्ट लॉ, देन द गारंटर इज नॉट रिस्पॉन्सिबल. नेक्स्ट वन, कॉन्ट्रैक्ट ऑफ गारंटी कैन बी ओरल एंड रिटन. Now, why this point is there? Contract of guarantee can be oral or written, but in actual practice, I don't think that you will be able to find a contract of guarantee which is in oral form. No one accepts a oral contract of guarantee which is in oral form, although the law says that it is valid. Why it says it is valid? Because the definition of contract says that any agreement, whether oral or written, which is enforceable by law is valid. But when it comes to contract of guarantee, every party which is involved in contract of guarantee tries to make sure that when it comes to approaching the court, it should be easier to prove that there was a breach of contract in contract of guarantee. If it is oral in nature, although it is acceptable, but if it is broken, then it is very difficult to prove in the court of law. मुझे लोन चाहिए, बैंक मैनेजर मेरे पहचान का है, मैं बैंक मैनेजर को अप्रोच करता हूं, मुझे डॉक्यूमेंट की लिस्ट दी जाती है, मैं सारे डॉक्यूमेंट सबमिट कर देता हूं. बैंक मैनेजर मुझे कहता है कि आपको 2 लोग लाने पड़ेंगे या कम से कम एक व्यक्ति तो चाहिए जो आपकी गारंटी लेगा. मैं मेरे फ्रेंड को लेके आता हूं, मेरा फ्रेंड ओरली बता देता है बैंक मैनेजर को, ठीक है आप इनको 5 लाख रुपए सैंक्शन कीजिए, मैं यहाँ पर आपको ये गारंटी देता हूं कि अगर ये नहीं रीपे कर पाए आपका 5 लाख का लोन, कोई भी बैंक चाहे आपका पहचान का हो, ऐसे कॉन्ट्रैक्ट पे साइन कर सकता है क्या जहां ओरल गारंटी दी जा रही है? देयर वी कैन नॉट ask the bank or force the bank that as it is written in the law that oral guarantee is also valid, oral guarantee is also acceptable, you have to accept this oral type of guarantee also. There outrightly the bank is going to reject your proposal. The reason behind is very simple, that if there is breach in the contract of guarantee and when the bank will be approaching the court will be demanding, the court will be asking for evidences or for proofs, and at that particular time if oral guarantee is there, then it is very difficult to prove in the court of law. ओरल जो मेरा फ्रेंड था जिसने गारंटी दी, उस फ्रेंड को अगर कोर्ट में बुलाया गया और उससे अगर जज ने पूछा या वकील ने पूछा कि आपने 5 लाख रुपए की गारंटी दी थी क्या, अगर वो सीधा बोल देता है नहीं मैंने नहीं दी थी, then it is not possible for the bank to prove in the court of law that the person is lying. अगर मतलब उसका ऑडियो रिकॉर्डिंग नहीं है, वीडियो रिकॉर्डिंग नहीं है, कुछ भी नहीं है, सिर्फ ओरल था, तो प्रूफ करना बहुत 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 मुश्किल. इसीलिए कॉन्ट्रैक्ट ऑफ गारंटी इज ऑलवेज इन रिटन फॉर्म. वन मोर थिंग everyone should understand is that it is always said, we are aware of it also, that whenever you are giving guarantee for a person, try to be 100% sure that the person will not be making a default. Otherwise the person who has signed as a guarantee, as a surety, will definitely be in deep trouble for no reason, because creditor is getting the principal amount as well as the interest, debtor is getting the loan for his personal use, guarantor is getting only tension. So that is why it is said that, and it is known also that it is very difficult to get a guarantor who can sign on your behalf. मेरा बहुत अच्छा फ्रेंड भी होगा तो वो नहीं करेगा साइन शायद जल्दी, मेरा रिलेटिव भी अगर रहेगा तो शायद वो जल्दी साइन नहीं करेगा. क्यों नहीं करेगा? क्योंकि सबको पता है कि अगर मैंने डिफॉल्ट किया तो उन्हें भरना पड़ेगा. तो हम जब भी लोन लेने जाते हैं तो अक्सर यही देखा जाता है कि जो बहुत क्लोज रिलेटिव है वही हमारे गारंटी साइन करते हैं. क्यों साइन करते हैं? बिकॉज दे आर रिलेटेड, ब्लड रिलेटिव है या बहुत ही ज्यादा क्लोज फ्रेंड्स हैं, तो वही लोग साइन करते हैं, बाकी लोग साइन नहीं करते. क्यों? क्योंकि इसमें रिस्क बहुत 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 ज्यादा है. सो दैट इज why it is always said that contract of guarantee should always be in written form. Next one, a contract of guarantee without consideration is void. Without consideration, here we are talking about only the consideration which is involved between the principal debtor and the creditor. We are not taking into consideration the third person or the third party named surety or guarantor. तो यहाँ पर जो कंसिडरेशन इन्वॉल्व होना चाहिए, जो लेन देन इन्वॉल्व होना चाहिए, वो किसके बीच में होना चाहिए? वो सिर्फ दो लोगों के बीच में होना चाहिए, एक लोन देने वाला, एक लोन लेने वाला। जो गारंटर है उसको कुछ भी नहीं मिलता है। Now we will check what are the different types of guarantee. First one is called as retrospective guarantee or prospective guarantee. Then we will discuss about what is fidelity guarantee, what is specific guarantee, and what is continuing. Am I audible to all?
Yes, sir.
Huh. What's the time?
1940, sir.
Okay, 1940. Okay, so we are having 20 minutes. Please stop me whenever it is 8. Okay, so we will discuss about these types of guarantee. So retrospective and prospective guarantee. So a guarantee which is given for future debt is called as prospective guarantee. The guarantee which is given for past debt is called as retrospective guarantee. पास्ट में जो कर्जा लिया गया उसके लिए अगर कोई गारंटी दी जाती है तो वो रेट्रोस्पेक्टिव गारंटी है। जो कर्जा आगे कोई लेने वाला है उसके लिए अगर कोई गारंटी दी जाती है तो वो गारंटी प्रोस्पेक्टिव गारंटी कहलाएगी। नाउ फिडेलिटी गारंटी, एनीवन अवेयर ऑफ फिडेलिटी गारंटी? व्हाट इज फिडेलिटी गारंटी? Now those who are working, they are aware of this type of guarantee. Even if you have not come across this term fidelity guarantee, but in other terms or in other words, you might have observed this type of guarantee in your organization also. So fidelity guarantee is a type of guarantee which is given for the conduct or behavior of a person. Earlier in other type of guarantees we had discussed that it was related to some sort of debt. कुछ कर्जा है, कर्जा लिया है, वो कर्जा चुकाने के लिए गारंटी दी जाती है। बाकी सारी गारंटीज जो है वो सिर्फ और सिर्फ डेट से रिलेटेड। यहां पर एक ऐसे टाइप की गारंटी है जो किसी व्यक्ति के कैरेक्टर से, कंडक्ट से या बिहेवियर से रिलेटेड, एंड दैट guarantee is called as fidelity guarantee. So the definition of fidelity guarantee is very simple. When a guarantee is given by one person on the conduct, behavior of the person, it is known as fidelity guarantee. Now suppose I'm working in an organization and there is a vacancy in my organization, and I know someone who can fit into that vacancy. I approach my higher authorities and I inform them that I know a person who I feel that fits in this particular job role or in this particular vacant position. I can assure you that he will be 100% fit for this job. He is a nice person, a good behaved person, and he is always having a good relation with the other persons. So by informing or updating my higher authorities, I'm trying to give a fidelity guarantee of my known one, friend, or a relative whom I feel that he is the right person for that particular job. So what I'm doing is I'm sharing my experience, and on that basis of that experience, I'm taking guarantee for his conduct, behavior, which will be displayed by the person when he will be joining the organization. And that type of guarantee is called as fidelity guarantee. In the students who are already working, particularly in IT companies or service organizations, we can say, there is a system which is called as employee referral for recruitment. Whenever there is recruitment in the organization or hiring in the organization, this particular policy is being implemented in many of the IT companies. And this practice is called as employee referral. The meaning of employee referral is very simple. The vacant position is displayed on the notice board, as well as it is shared to all the employees of the organization, that in our organization we are having vacancy for this position. If you know someone who can fit into this particular vacant position, you can share the details to the HR department. And this particular system is called as employee referral. Same thing is exercised in fidelity guarantee. A person, when he comes to know that yes, there is a vacancy in my organization and my friend is best suited in this organization, he approaches the HR department and informs the HR department that my friend has done graduation or post graduation, his skills are this, his qualification is this, and I feel that he fits into the organization in that particular vacant position. He also gives the guarantee for गुड कंडक्ट ऑफ द पर्सन. अगर आपने उसको रिक्रूट किया तो वो सबसे अच्छा बिहेव करता है, वो बहुत पंक्चुअल है, वो सिंसियर है, हार्ड वर्किंग है. ये जो कैरेक्टरिस्टिक्स जो बताई जाती हैं, ये सब क्या है, फिडेलिटी गारंटी का पार्ट हो जाता है कि ऑन बिहाफ ऑफ दैट पर्सन you are informing the management or your organization that the person is possessing this qualities, and you are sure that he will be exhibiting all these qualities in work also, and that is called as fidelity guarantee. Next one, specific guarantee. Very simple. If we know the meaning of specific, rest everything is simple. Specific means for a particular thing. Specific guarantee. Now my friend has taken guarantee for a specific thing, and that specific is what? That I have taken a loan of 5 lakh rupees from the bank. For that particular transaction, my friend has signed as a witness or has signed the surety contract, that in case he is unable to pay the loan, I shall repay his loan. So when the guarantee is given for a particular transaction, a specific transaction, then we can say this can be called as specific guarantee, because it is given for a specific purpose or specific transaction. एक ही ट्रांजैक्शन हुआ, स्पेसिफिक ट्रांजैक्शन हुआ, उसके लिए उसने वो साइन किया, वो लोन पूरा कॉन्ट्रैक्ट खत्म हो गया. मैं ये नहीं कह सकता कि उसने एक बार साइन किया है तो वो हर बार साइन करेगा, बिकॉज दैट वाज स्पेसिफिक गारंटी. guarantee given for a single transaction is called as specific guarantee. Now next one is called as continuing guarantee. Continuing guarantee means, as the term itself suggests, which is continuous in nature. ऐसी गारंटी जो लगातार चली जा रही है और एक सीमित समय तक वो गारंटी वैलिड रहेगी. So that guarantee is called as continuing guarantee. Specific guarantee, we have seen that only single transaction, एक ट्रांजैक्शन के लिए जब कोई व्यक्ति गारंटी देता है तो वो स्पेसिफिक गारंटी कहलाएगी, क्योंकि उसने उस स्पेसिफिक ट्रांजैक्शन के लिए ही गारंटर बनना निश्चित किया है. यहां पर क्या है, अभी कंटिन्यूइंग गारंटी में नाम ही उसका क्या है, कंटिन्यूइंग गारंटी, मतलब लगातार चलने वाली गारंटी. वो गारंटी एक ट्रांजैक्शन के लिए नहीं है, वो शायद 2 के लिए हो सकती है, वो 3 के लिए हो सकती है, वो 5 ट्रांजैक्शन के लिए हो सकती है, या ज्यादा ट्रांजैक्शन के लिए भी हो सकती है. अब मुझे पैसे की जरूरत है, मैंने बैंक में अप्लाई किया, तो बैंक का प्रोसीजर बहुत टीडियस है, बहुत टाइम कंज्यूमिंग है, बहुत लेंदी है, इसीलिए मैंने प्राइवेट मनी लेंडर के पास अप्रोच करना उचित समझा. मैं मनी लेंडर के पास गया, उसने मुझे बताया आई एम रेडी टू गिव यू दी लोन, बट गारंटर चाहिए. मनी लेंडर को भी गारंटर चाहिए. अब मेरा फ्रेंड गारंटी के लिए तैयार है. अब मुझे उससे 2-3 बार पैसे चाहिए. मैंने कॉन्ट्रैक्ट ऐसा किया है कि मुझे पहले 1 लाख रुपया चाहिए, उसके बाद 2 महीने के बाद मुझे 3 लाख रुपया चाहिए, उसके बाद 1 महीने के बाद मुझे वापस से 2 लाख रुपए चाहिए. तो ऐसा 6 लाख रुपए मैं 6 महीने में उससे लेना चाहता हूँ, या 3 महीने में, 4 महीने में मैं लेना चाहता हूँ. तो ये एक ट्रांजैक्शन नहीं है, ये 2, 3, 4 ट्रांजैक्शन हमारे बीच में होने वाले. किसके बीच में? मेरे बीच में, जो प्रिंसिपल डेटर है, और मनी लेंडर जो क्रेडिटर है. अब ये चीज मेरे फ्रेंड को बताई जाती है, वो बोलता है कि ठीक है, 3 ट्रांजैक्शन हो, 4 ट्रांजैक्शन हो, 5 ट्रांजैक्शन हो, आई एम रेडी टू टेक द गारंटी. व्हेन फॉर अ मल्टीपल ट्रांजैक्शन a surety is taking the guarantee, then it is called as continuing guarantee. 6 महीने तक जितना भी इसे पैसा चाहिए उतना पैसा आप इसे दीजिए, मैं गारंटर हूं. अगर ऐसा श्योरिटी बोलता है किसे, क्रेडिटर को, तो क्या है, कंटिन्यूइंग गारंटी. यहां पर ये गारंटी कब तक वैलिड है, कितने भी, चाहे वो 2 ट्रांजैक्शन हो, 5 ट्रांजैक्शन हो, या 5 से अधिक हो, 6 महीने तक जो भी आप ट्रांजैक्शन कर रहे हैं वो सारे ट्रांजैक्शन किसके अंदर आ रहे हैं, कंटिन्यूइंग गारंटी. सो दैट इज द मीनिंग ऑफ कंटिन्यूइंग गारंटी. और उसकी समय सीमा क्या निश्चित की गई है, 6 महीने तक. तो 6 महीने तक डेटर और क्रेडिटर के बीच में जितने भी ट्रांजैक्शन होंगे लेन देन के, लोन से रिलेटेड, वो सारे ट्रांजैक्शन के लिए अगर कोई गारंटी लेता है तो वो गारंटी कंटिन्यूइंग गारंटी कहलाएगी 6 महीने तक के लिए. 6 महीने के बाद जो समय सीमा खत्म हो गई, उसके बाद वो कॉन्ट्रैक्ट ऑफ गारंटी खत्म हो जाए. अगर अब समय सीमा खत्म हो गई किसकी, कंटिन्यूइंग गारंटी की, इसका ये मतलब नहीं है कि गारंटर नाउ इज फ्री. गारंटर अगर 6 महीने के अंदर मैंने वो सारा लोन रीपे कर दिया, तो यस, गारंटर इज नाउ फ्री फ्रॉम हिज कंटिन्यूइंग गारंटी रिस्पॉन्सिबिलिटीज. अगर मैंने 6 महीने में वो लोन पूरा रीपे नहीं किया, आधा रीपे किया, 5 लाख में से 2.5 लाख किया, 2 लाख किया, 3 लाख किया, कुछ 1, 2, 3 लाख रुपए बचे, तो जब तक मैं वो रीपे नहीं कर दूंगा तब तक उसकी, गारंटर की छुट्टी यहां से होने वाली नहीं है. वहां नहीं बोल सकता वो कि 6 महीने हो गए, अब मेरा कुछ लेना देना नहीं. जब तक कॉन्ट्रैक्ट खत्म नहीं हो जाता तब तक उसका पूरी रिस्पॉन्सिबिलिटी रहेगी. कब तक? जब मैं 5 लाख पूरे दे दूंगा, वो कॉन्ट्रैक्ट क्लोज हो जाएगा, इंटरेस्ट मिल गया, सब मिल गया, कॉन्ट्रैक्ट क्लोज. दैट मीन्स दैट इज द एंड ऑफ द रिस्पॉन्सिबिलिटी ऑफ guarantors continuing guarantee, otherwise it will be carried forward. So these are some of the types of guarantees. Now revocation of continuing guarantee. Up continuing guarantee, now we know that what is continuing guarantee. When for a number of transaction over a period of time, when somebody is taking that guarantee is called as continuing guarantee. Now, revocation means, the meaning of revocation word is cancellation. Revocation of continuing guarantee means cancellation of continuing guarantee. So when we can cancel the continuing guarantee, or is it possible that it can be cancelled, or it is not at all possible, or in which condition it is possible that we can cancel the continuing guarantee, in which conditions it is not possible that we can cancel the continuing guarantee, that we are going to discuss. Now first, continuing guarantee is by a notice of revocation to the creditor. By a notice to the of revocation is cancellation. So by a notice of cancellation to the creditor. Now Mr. A is creditor, Mr. B is debtor, and Mr. C is a surety or guarantor. Now, when this Mr. C is relieved, or when he can cancel the continuing guarantee, earlier he has signed a contract of guarantee for Mr. B, that is principal debtor, that for multiple transaction for a period of 6 months, I take the responsibility of all the transaction within this period of 6 months. After 1 month, if the guarantor feels that now it is not possible for him to take the guarantee for future transaction, immediately he can apply to the creditor for revocation or cancellation of guarantee or continuing guarantee for next transactions. For earlier transaction he cannot cancel. 6 महीने के लिए कंटिन्यूइंग गारंटी दी गई, 6 ट्रांजैक्शन वो 6 महीने में होने वाले, उसकी गारंटी किसने ली है? श्योरिटी। पहले ही ट्रांजैक्शन के बाद श्योरिटी को ऐसा एहसास हुआ कि बहुत ज्यादा रिस्क है, मुझे ये ट्रांजैक्शन, ये जो कंटिन्यूइंग गारंटी का कॉन्ट्रैक्ट है कैंसिल कर। इमीडिएटली वो गारंटर क्रेडिटर को अप्रोच करता है, उसे रिटर्न में लिख के देता है कि मुझे मेरी गारंटी की कॉन्ट्रैक्ट कैंसिल करनी है, आगे के जो भी होगा, आगे के जो 5 ट्रांजैक्शंस बचे हैं उसका गारंटी मैं नहीं लेना चाहता, और वहां पर उसकी रिस्पॉन्सिबिलिटी फ्यूचर में जो 5 ट्रांजैक्शन डेटर के साथ क्रेडिटर के होने वाले थे, वहां पर उसकी जो रिस्पॉन्सिबिलिटी है वो खत्म हो जाएगी। पर यहां पर उसका जो रोल है गारंटर का प्रीवियस ट्रांजैक्शन के लिए, वो वैलिड रहेगा। यहां पर गारंटर ये नहीं बोल सकता कि मैंने तो कैंसिल कर दिया है, मेरी तरफ से अप्लाई कर दिया, क्रेडिटर ने मान लिया, क्रेडिटर के मैंने रिटर्न में साइन ले लिए, ये मेरे पास सब कुछ है, अब कॉन्ट्रैक्ट ऑफ गारंटी कैंसिल हो गया। तो कॉन्ट्रैक्ट ऑफ गारंटी किसके लिए कैंसिल हुआ है? फ्यूचर में जो ट्रांजैक्शन 5 होने वाले थे, जो अभी तक नहीं हुए हैं, उनके लिए वो कैंसिल हुआ। बट पास्ट में जो एक ट्रांजैक्शन हो गया है उसके लिए वो वैलिड रहेगा। कब तक वैलिड रहेगा? जब तक कि डेटर वो एक ट्रांजैक्शन का जो भी अमाउंट था, जो भी टर्म्स कंडीशन के साथ था, वो जब तक वो क्रेडिटर को रिटर्न नहीं करेगा तब तक वो रिस्पॉन्सिबिलिटी रहेगी। सो दैट इज कॉल्ड एज a note by way of notice of revocation to the creditor. Next, और सबसे सिंपल, how surety is relieved from his responsibility is by way of death. अगर श्योरिटी की डेथ हो गई तो द मोमेंट ही इज नो मोर और शी इज नो मोर, the contract of guarantee, whether it is specific guarantee, retrospective guarantee, prospective guarantee, or continuing guarantee, it is closed, it is over, it is completed. क्योंकि दूसरे कॉन्ट्रैक्ट्स में what we have seen that suppose if as a debtor if I am taking loan from bank, I have to return that loan. Now this return of loan will be there even if I am no more. Suppose if I am no more and I have taken a loan of 10 lakh rupees, which or some of the amount which I need to repay to the bank, which is still there. Now what the procedure is? Procedure is very simple. The procedure is says that the pending amount can be recovered from the legal heirs of the deceased person, the person who is no more. जो व्यक्ति मृत हुआ है उस व्यक्ति ने जितना लोन लिया है, अगर जितना भी उसका बचा हुआ है तो वो खत्म नहीं होता वो क्या होगा, वो उसका जो भी उसके डिपेंडेंट्स हैं उनके पास ऑन होता है। पर गारंटी में क्या है, अगर किसी ने गारंटी दी है, अगर मैं किसी कॉन्ट्रैक्ट में गारंटर हूं, श्योरिटी हूं, तो द मोमेंट आई एम नो मोर माय पार्ट इज ओवर। वो पार्ट मेरे जो लीगल हायर, मेरे जो डिपेंडेंट्स होंगे, मेरी वाइफ, मेरे बच्चे, उनको वो ट्रांसफर नहीं हो सकता, वहीं पे वो खत्म हो जाए। तो दूसरे केस में वो ट्रांसफर होता है, कॉन्ट्रैक्ट ऑफ गारंटी में वो खत्म हो जाता है। सो डेथ by death of the surety, automatically all the contracts of guarantee gets dissolved. Next one.
Sir, it's 8 o'clock.
Acha, okay, thank you for reminding. So what we will do is we will just discuss, give me just 1 or 2 minutes, we will complete this and then we will close the session.
Okay, sir.
The second is third one is by variation in the contract without the knowledge or consent of the surety. That also we had discussed. Variation means making changes in the contract. Now if the creditor is in the position of the contract and without the knowledge of the surety, if he makes any changes in the terms and condition of that particular contract, which later on the surety comes to know that I had signed on these terms, now the creditor has changed these terms without my knowledge, then automatically his responsibility is over. Next one, by release of principal debtor without the consent of the surety. Now this is again very simple. Why this ends the continuing guarantee? The principle is very simple, that primary liability or primary responsibility or first responsibility of repaying the loan is with the debtor, not with the creditor. creditor कब पिक्चर में आता है? जब डेटर डिफॉल्ट करेगा तब क्रेडिटर वो उसका जो भी लोन है वो चुकाएगा। यहां पर क्या है कि बाय रिलीज ऑफ प्रिंसिपल डेटर विदाउट द कंसेंट ऑफ श्योरिटी। प्रिंसिपल डेटर श्योरिटी को क्रेडिटर से जाके मिलता है, मैं बीमार रहता हूं, मेरी नौकरी नहीं है, तो प्लीज मुझे इस कॉन्ट्रैक्ट में से मुक्त करो और मेरा जो भी बकाया है वो सारा श्योरिटी से ले लो। बिना श्योरिटी को बताए अगर वो क्रेडिटर अगर डेटर को रिलीज कर देता है, डेटर के साथ का कॉन्ट्रैक्ट कैंसिल कर देता है, तो भी श्योरिटी की रिस्पॉन्सिबिलिटी खत्म हो जाती है। बाय कंपाउंडिंग विथ प्रिंसिपल डेटर, कंपाउंडिंग मतलब उसका मीनिंग जो वर्ड कंपाउंडिंग है उसका मीनिंग है साठगांठ करना, किसी के साथ गलत तरीके से कोलैबोरेट करना। अगर डेटर और क्रेडिटर के बीच में कुछ गलत डील होती है, और वो डील के अंडर अगर क्रेडिटर, डेटर को माफ कर देता है कि ठीक है तू नहीं भरेगा तो भी चलेगा, मैं गारंटर से वसूल करूंगा, और बाद में गारंटर को अगर इस बात का पता चलता है और वो कैंसिल कर देता है तो भी उसे पूरा रीपे करने की जरूरत नहीं है, वो कॉन्ट्रैक्ट खत्म हो जाएगा। बाय इनवैलिडेशन ऑफ द कॉन्ट्रैक्ट विच इंक्लूड्स कॉन्ट्रैक्ट ऑफ मिसरिप्रेजेंटेशन, गलती से अगर कोई कॉन्ट्रैक्ट पे साइन हुआ है, जैसे ही पता चला, जैसे ही गलती का एहसास हुआ, कॉन्ट्रैक्ट चालू होने से पहले अगर ये सब चीजें पता चल गई तो भी कॉन्ट्रैक्ट कैंसिल हो सकता है। लास्ट वन, बाय फेलियर ऑफ को श्योरिटी ज्वाइनिंग द कॉन्ट्रैक्ट ऑफ गारंटी। को श्योरिटी मींस यहां पर एक श्योरिटी की जगह दो श्योरिटी हैं या दो से अधिक को श्योरिटीज। तो बैंक में एक ही श्योरिटी चाहिए था, पर जो गारंटर है वो ये कंडीशन रखता है कि मैं गारंटी तभी दूंगा जब एक और गारंटर इस कॉन्ट्रैक्ट पे साइन करेगा, दूसरा कॉन्ट्रैक्टर जब साइन करेगा तभी ये कंटिन्यूइंग गारंटी का कॉन्ट्रैक्ट वैलिड माना जाएगा, क्योंकि कंडीशन था। अगर दूसरा साइन नहीं करता है, पहले ने अगर साइन कर दिया है तो भी ये वैलिड नहीं होगा, ये कैंसिल हो जाएगा। सो दैट इज हाउ cancellation of continuing guarantee can be done. So thank you all for today's session. We will meet maybe on Monday. So before the end of the session, just an important announcement. Tomorrow at 11:30, our Honorable Founder Secretary, Dr. Shilpa Kulkarni Madam, will be conducting one session which will be related to your personality. So how you can develop your personality, that she will be giving you some mantras, some tips. So at 11:30, all the students are requested to be present for that particular session. Please communicate in your friends group also that it is compulsory for all to be present for tomorrow's session. Two sessions will be conducted, one at 11:30 and the other one will be at 6 to 8, that is SAP training, certificate training. And we will be having two regular classes, one class at 7 in the morning, then 8 in the morning, and then 11:30 Dr. Shilpa Kulkarni Madam will be conducting the session, and 6 o'clock to 8 o'clock we will be having session on SAP training. So thank you everyone.
Hello, sir. Hello.
Yes. Please
Sir,
go ahead.
sir,
We are
just a small question. Like,
Yes.
ऐसी कौन सी cases होंगी जब guarantor is liable to pay?
That can be discussed in the next session. You also come
Okay.
prepared. I'll give you
Okay, sir.
examples also. I'll give you the cases also, right?
Okay, sir.
Because we have
Thank you.
already consumed 5 minutes of the other session. Hello.
Yes, sir. Sure. Thank you.
Please. Okay. Thank you.